Good morning.
Good morning.
Thank you very much. Ms Simcock, good morning.
Thank you, Chair. The witness today is Dr. Hard.
Good morning.
Good morning.
If you could repeat after me, please. I do solemnly,
Sincerely and truly
declare and affirm
that
the evidence I shall give
shall be the truth,
the whole truth,
and
nothing but the truth.
nothing but the truth.
Thank you. Can you give your full name to the inquiry, please?
My name is Dr. James Jesse Hard. I'm known to everybody mostly as Jake.
Thank you. Dr. Hard, you've prepared two reports for the purposes of the inquiry. You're the independent medical expert instructed by the inquiry to give your opinion on clinical matters relevant to the terms of reference. Is that right?
Yes.
Those two reports are at the original one at INQ 4075 and the supplemental report at INQ 30112, and I think you have hard copies in front of you if you wish to refer to them during your evidence. I'd ask that those two reports are reduced in full, Chair, and what that means, Doctor, is that I don't intend to deal with every single line in each of those reports, but to ask you some questions about some of the aspects that you cover there. First of all, what qualifications do you hold, please?
A Bachelor of Medicine and Surgery from University College in London, 1998, and membership of the Royal College of GPs, which is my GP qualification, I think 2006.
Thank you. You've worked in various custodial environments, is that right? Mainly prisons?
Yes, predominantly prisons since 2006. In fact, my first job was working in a prison, and I continue to work in prisons, and I have done over the last 15 years.
And just give us some examples of which prisons you've worked in.
Well, I've worked in prisons in England and Wales. So my first prison was in Leicester. I worked then in Park Prison for about 6 years, which is a private prison in Wales. I've worked in Swansea Prison, Eastwood Park Prison, which is a ladies' prison. And then most recently, I'm now working in HMP Cardiff.
Thank you. Do you also hold some other roles? You say you're chair of the Royal College of GP's Secure Environments Group, is that right?
I was until March the 10th, so I've just handed over the new chair, Dr. Caroline Watson, so I've after 6 years of holding that role, 2 3-year tenures.
And what did that role entail briefly?
Coordinating a UK-wide group membership of GPs working in secure environments, prisons and immigration removal centres, and working at a high level with policy and strategy people from, for example, NHS England in Improvement, HMPPS and PHE as they were known, and now UKHSA.
You say you are an associate advisor to the Parliamentary and Health Service Ombudsman and provide clinical advice across the general practice, substance misuse and prison domains. Is that right?
Yes, in fact, I've done advice and guidance for all of the ombudsmen across the 3 areas where ombudsmen are. And
you also say you've been a clinical reviewer commissioned by NHS England to assist the prison and probation ombudsman with death in custody investigations.
Yes,
right?
So I've done about 15 of those, including 1 murder and 1 level 3 clinical review, which is ongoing.
You say you've contributed to the NICE guideline development group for the physical health of people in prisons. Is that right?
Yes.
And what does that involve?
So the guideline development group involved a team of researchers for NICE, and then on the other side a panel of subject matter experts, and I was there as a GP contributing to the development of that guidance.
Do you have any experience of working in immigration removal centres?
Not directly, no. I've never worked in an immigration removal centre.
Have you visited Brook House for the purposes of this inquiry?
I have, yes.
You were also instructed by the coroner as the independent expert in the inquest into the death of Prince Fosu in Harmondsworth IRC, is that right?
That's correct.
And just very briefly, what were the particular issues that arose in that investigation?
Prince Kwabena Fosu was a 31-year-old man who died after 6 days of arriving in Harmondsworth IRC. It was his second visit to the IRC. He died essentially of dehydration and self-neglect, likely to have been severely mentally unwell, and died within 6 days of his arrival there.
Thank you. For the purposes of preparing your reports for the inquiry, you've read a large number of documents, including the detention centre rules, the various DSOs, including the one on Rule 35, the adults at risk policy, and the statutory guidance, and various other policy documents. Is that right?
Yes.
You've also looked at various contemporaneous documentation from Brook House from the relevant period, I think, such as medical records, ACDT documents, and use of force forms. Is that right?
Yes.
You've also read a large number of witness statements, I think, from, in particular, the GPs working at Brook House and from healthcare staff. Is that right?
Yes.
And also from formerly detained persons.
Yes.
You've read the transcripts of the live evidence of the healthcare staff and also of the witnesses from Freedom from Torture and Medical Justice. Is that right?
Yes.
Have you watched some of the live evidence as well?
Yeah.
Who did you watch live in particular?
So I've seen Sandra Calver's evidence, I have seen Dr. Uzarali's evidence and Dr. Chowdhury's evidence. I have also seen Teresa Schleicher's evidence and Dr. Bingham's evidence.
So do you consider that you have a good understanding of the role of healthcare in an immigration removal centre?
Yes.
And also of what was happening on the ground in Brook House in 2017?
Yes.
IRCs operate as a different detention environment to prison. Would you agree?
Yeah.
Because, in particular, detainees are not in an IRC by order of a court as a result of a sentence, but rather because of an administrative power being exercised by the Home Office. Is that right?
That's my understanding, yes.
There's no time limit to immigration detention.
Not as I understand it.
So that's why, in the context of immigration detention in particular, there are additional rules and policies such as the detention centre rules, the adults at risk policy and the DSOs, which aim to identify people who might be harmed by remaining in detention so that they can be removed from that environment. Is that right?
Yes, I think so, but I think I would want to add to that it's also based on my understanding of the nature of the patients that are coming in to the immigration removal that suffer from a number of likely prevailing conditions that also make them particularly at risk. So that's why those safeguards are there.
It's a particularly vulnerable population.
Yes.
The role of healthcare, then, in an immigration removal centre is not just to provide primary healthcare to patients, but to provide important clinical safeguards which identify those who are vulnerable to harm in detention and to notify the Home Office of those people so that their detention can be promptly reviewed by the Home Office and that they may be removed from detention unless there are exceptional circumstances to detain them. Is that your understanding?
Yes.
Notification to the Home Office of a vulnerable person isn't a purely administrative task. It's the role of healthcare professionals to advocate for their patient. Is that your understanding?
Yes, and I think I think it's a special additional task that's required, particularly of the GPs with their role, that goes above and beyond what I've seen, certainly from a prison environment or any other normal primary care environment that I've worked in.
Yes, it's very particular to immigration removal centres.
Yes.
Notifying the Home Office is an important patient safeguarding role for an IRC doctor and indeed healthcare staff, because that role is informing the Home Office of vulnerabilities which mean that there's a risk they might be harmed by detention. Is that right?
Yes.
And that role isn't a one-off at the outset of detention. It remains a continuing role and obligation for as long as the person is detained. Is that your understanding?
Absolutely, yes.
And would you agree that it would be reasonable to expect a healthcare professional to use all of the available tools at his or her disposal to inform the Home Office about a patient who is particularly vulnerable to harm if he remains in detention?
Yes, and I would go further to say that they would need to have a very good understanding of what those rules are and what the purposes of those are in order to be able to do that effectively.
Yes, thank you. I want to look then at some of those rules and safeguards. If we look first at a detainee's arrival into an immigration removal centre, there is a reception health screening process that occurs as soon as someone arrives into an immigration removal centre. Is that right?
Yes.
There are 2 stages to the clinical health screening carried out in an IRC on a detainee's arrival. The first is by a nurse, which should take place within 2 hours of their arrival. Is that right?
Yes.
The second is then an appointment with a GP, which should take place within 24 hours of arrival. Is that your understanding?
I have come to understand that. I don't think I understood it as clearly as that when I first got involved in this particular work and when I wrote my first report, but I have a clear understanding of that particular mechanism and the value of that, having watched some of the evidence over the last few days. So I think that probably needs further understanding and exploration generally.
Yes, it's difficult to understand simply from the face of the rules.
Yes, and I guess what I'm saying is that having reviewed the material before the oral evidence, it wasn't actually clear from the clinical records what was actually happening with regard to the GP's assessment of Rule 34.
Yes, we'll perhaps come to that in a bit more
Yep.
detail in a moment. So the appointment within 24 hours, your understanding now is that that's required by Rule 34 of the detention centre rules, is
Yes.
that right?
Yeah.
And if we just look then at the rule, if we could have on screen please CJS 006120. Here we see the detention centre rules front page, and if we could go to page 11 please. There we see Rule 34, which says every detained person shall be given a physical and mental examination by the medical practitioner or another registered medical practitioner in accordance with Rules 33 within 24 hours of his admission to the detention centre. You say at paragraph 6.2.2.4 of your original report that the primary focus of the screening process is to highlight any health issues that may place a person at risk in the early days in custody if steps are not taken to address these, and you give some examples. For example, immediate risks may include overt plans to self-harm or act on suicidal plans, prescribing of medication that, if missed, could lead to significant health consequences, for example, anti-epileptic medication, or the acute management of drug and or alcohol withdrawal. So certainly one purpose of the appointment with a GP within 24 hours would be to highlight any immediate health issues that need to be addressed for the patient's safety and well-being. Is that right?
Yes, in particular reference to this paragraph, I'm focusing here on the nursing assessment in order to be able to highlight these specific possible risks to the GP for their further assessment the following day. So that's one component of it.
Yes. And you say in your supplemental report at page 56 that Rule 34 is inherently important for the early identification of ongoing health needs of an individual on arrival in a place of detention, and is crucial for the planning of the detained person's care whilst in Brook House or any other secure or detained setting. Is that right?
Yes.
So it's important for identification of health needs in order for them to be appropriately addressed through treatment or other referral.
Yes.
There is, though, that the second very important purpose of Rule 34, which is this clinical safeguarding role, which we've looked at briefly, and that functions to identify the need for a Rule 35 report, doesn't it?
I would agree, yes.
So the absence of any compliant examination under Rule 34 means that an important piece of clinical evidence relevant to the consideration of decision-making concerning the exercise of detention powers is missing. Would you agree with that?
I think the timeliness of the Rule 34 component is essential, given that there is to my understanding, not very much done pre-detention to identify people who may be at risk of being in detention. So, as you say, if this component of Rule 34 is not undertaken at the earliest outset, then it is going to lead to further delays in the detection of that deterioration.
Yeah. So Rule 34 is not just for a purpose of identifying health needs and addressing them in detention. It's the first opportunity to identify vulnerabilities and risk factors leading to likely harm if detained.
Yes.
A Rule 35 report can and should be completed and notified to the Home Office at the end of a Rule 34 examination, so detention can be reviewed at that very early stage if a Rule 35 report is appropriate.
That's my understanding, yes.
So in that way, the two rules, Rules 34 and 35, are designed to work together as the safeguard.
At this point in time, yes. Yeah.
And it's particularly important, as you've said at the outset, that safeguard is operating at the outset of detention. And that's because of the possibility of harm eventuating if it doesn't. Is that right?
Yes.
So it's essentially the first opportunity to prevent the exposure to a risk of harm of a vulnerable detainee.
Yes.
From the evidence that we've heard and you've now considered, it seems that there were a number of different types of deficiencies in the way that the rules were operating on the ground in the relevant period, and indeed still today. Is that right?
Yes.
I'd just like to look at some of those with you then in a little more detail and see what your view is on them. So we heard some evidence that the nursing screen that we've referred to, which is the first opportunity that screening is done should be within 2 hours of arrival, was sometimes really the only appointment which occurred, and so was effectively being treated as the Rule 34 appointment. Would you agree with that?
That appears to be the case, yeah.
That nursing screen is clearly not a full mental and physical examination as required by the rule. It's a more basic questioning process, sometimes described as a tick box exercise.
Yeah, I mean, it does, in the sort of purest physical and mental health sense, tick some boxes, as you say, in terms of identifying the commonly believed needs of a group of people coming into a secure setting, but it doesn't take the additional step of understanding what, or going further to explore those specific needs of the detainees when they're coming into that environment.
Yes.
Because of the risk of harm. So it seems to me that the purpose of the Rule 35 is not well understood by the people that are undertaking the screen, both at the nursing level and then subsequently at the GP appointment.
Yes. The nursing screen also can't fulfil the requirements of Rule 34, as the rule requires an examination by a medical practitioner,
Indeed,
a GP.
yes.
So if it's being treated as the Rule 34 appointment, that's in breach of the rule.
That would be my understanding, yes.
We heard some evidence that GP appointments are also not always, and indeed perhaps not often, done within 24 hours of a detainee's arrival in the centre in breach of the rule. Is that your understanding as well?
That's my understanding of having seen the oral evidence, yes.
Detainees are entitled to refuse the Rule 34 appointment. It's to be done by consent, is that right?
Yes, so yes, somebody would have to consent to the nursing screening as well as the Rule 34 appointment with the GP. I haven't seen anything so far that explains what is advised of the detainee of the purpose of those subsequent appointments or the potential appointment with the GP the following day.
Yes, it seems that there's some evidence that it's just not being explained to them, the purpose of a Rule 34 appointment. Is that your understanding?
It is, and I don't wish to say that it's the detained person's responsibility for that, but I do think it's the healthcare provider's responsibility to explain the importance of attending that appointment.
Yes, and not just to identify any health needs they have in order to treat them or to address those needs, but that very important clinical safeguarding role of that appointment. That's what should be being explained to them, is that right?
Yes, I think so.
Because otherwise, of course, it can't be an informed refusal to attend the appointment.
I agree, yes.
Dr. Uzarali and Sandra Calver, as the head of healthcare, gave evidence of a practice in relation to Rule 35 reports not being written or indeed considered at the Rule 34 GP assessment that's required within the 24 hours of arrival at the IRC. Instead, the practice appears to have been that a second assessment appointment was booked if something was flagged initially through the screening process, or in that appointment, sometimes booked after a considerable delay. So the safeguard in those circumstances isn't operating at the outset of detention, is it?
No, and I think it subsequently leads to delays in the detection of those vulnerabilities. And it feels to me a little bit like the priorities are somewhat misaligned here, because obviously the priorities, in my view, would be the safeguarding rather than delaying it. Dealing with that first would be my priority if I was in that position.
Yes. Dr. Bingham gave some evidence that process of that practice of booking that second appointment with some delay afterwards was inappropriate, because the whole purpose, as we've discussed, of the two rules is that they work together to identify people immediately and route them out of detention. So if instead there's a period of delay, a waiting period, as she put it, that means people may deteriorate in the meantime. Would you agree with that?
Yeah, absolutely. I think there is what appears to be a conflict between the delivery of the primary health services and the delivery of the safeguarding processes. And as I say, it appears to me that the priority is given to the primary care services rather than the safeguarding aspects of these rules.
Yes, and one might understand that part of the reason for that is that the delivery of primary care services is something that nurses and GPs understand very well, whereas this is something extra that is clearly not well understood.
Yes, I think, and so obviously over a very long period of time, I think that has been the case from my understanding so far, and all of the things that I've looked at, that priority going forwards needs to be, readjusted so that the safeguarding measures are the priority in a way. Now that obviously has significant implications for resourcing, etc. But ultimately, if the safeguarding components aren't effectively dealt with, then there are going to be delays, as you rightly said.
And harm caused as a result.
And harm caused, potentially, yes.
We heard from Sandra Calver that GP appointments within the first 24 hours at the time in the relevant period were 5 minutes long and are now 10 minutes long, and that's not enough time to do a Rule 34 compliant medical examination. Would you agree with that?
I can't possibly imagine how you would undertake to evaluate somebody's levels of risks thoroughly in 10 minutes. When I heard that, I questioned in my mind whether that's a 10-minute ledger appointment, i.e. a placeholder, whether it was actually physically 10 minutes worth of time allocated to that. We've also heard in terms of the length of time that it takes to do a thorough report from subject matter experts being, a considerable number of hours. So I can see that 10 minutes, even from the outset, isn't enough to do much more than
ask if they're okay.
A very, very cursory assessment.
Yes. So 5 or indeed 10 minutes certainly isn't adequate to carry out a full mental and physical examination in accordance with Rule 34.
Unless at that point the person said there is nothing for you to worry about, then if there was anything to be exposed at that point, then it would take a lot more than 10 minutes to get to the bottom of it.
Yes. Dr. Uzarali said it wasn't possible to do the sort of physical and mental state examination required at this initial GP appointment. He described it as it's almost like triage. Is that, in your view, to your understanding, what was effectively happening at that stage?
It would appear so. I think if you're going to triage, I guess that's the point I was making earlier about where the priorities lie. And I think even if you did have for the purposes of planning your day, a moment to triage a number of people that had come in the day before, you would then need to allocate some time the same day, in my view, in order to undertake that thorough assessment, which, as I said, I appreciate has implications for the resourcing and the planning of how you deliver your healthcare services. But nonetheless, if you triage and then say, well, I haven't got an appointment for 2 weeks, that to me is a significant delay that leads to potential harm.
Yes. So that evidence essentially shows that the arrangements at Brook House made it impossible to comply with Rule 34, the requirements of Rule 34 and indeed Rule 35 during the relevant period, and indeed the same today.
As I understand it, yes.
And that certainly accords with medical justice's experience as well. Is that your understanding?
That's my understanding, yes.
Where then that initial screening has detected any factors that indicate an adult at risk, the person is likely to be at risk of harm from their detention and shouldn't be in detention unless there are exceptional circumstances, but they are remaining in detention for that period of delay at least, aren't they?
Yeah, and again, I go back to the point that arguably if some of this information could be gathered pre-detention, then we wouldn't necessarily, or those patients, those detained persons, wouldn't be in that position in the first place. And I think that's essential to consider. Nonetheless, the system as it currently stands, the detained person arrives in detention, those safeguarding mechanisms, because of the prevailing health issues that we understand about them, need to be the priority.
Yes, and they're not, and so far as we can see from the evidence, that's a serious concern.
Yes.
That needs to be addressed.
Yes.
And again, the reason it's such a serious concern is that failure means those detainees are being directly exposed to risks of harm and actual harm in detention.
Yes.
A different further deficiency identified by the evidence seems to be that even where the nurse's screening identified certain vulnerabilities, such as, for example, a disclosure by a detainee that they had been a victim of torture, that wasn't always leading to either a Rule 34 appointment with a GP or a further Rule 35 assessment and report completed by a GP. Is that your understanding?
Yes.
Again, a very significant concern.
Absolutely.
Because, for example, if a nurse was told, I've been a victim of torture, that should be leading to consideration of the Rule 35 report.
I completely agree.
Under
yes.
Rule 35(3).
Yeah.
A practice seems to have developed, would you agree, that it was up to a detained person to ask for a Rule 35 report to be completed?
That certainly seemed to be the case with a number of detained persons' records that I looked at, and it seemed to be by request rather than, the clinical healthcare team actively pursuing and ensuring that those safety mechanisms were being utilised at the first available opportunity.
Yes, it wasn't their obligation to ask, it was the obligation of healthcare to identify and carry out their duties under the rules.
Yes.
I just want to look at briefly a document, a G4S document that was in place at the time. If we could show, please, CJS 006045 on screen, please. This is the detainee reception and departures G4S policy in place at the time in the relevant period. If we could look at page 21, please. And then if we could just go to the middle, so you can leave it there, thank you, but if Doctor, we look at the bottom, towards the bottom of the screen, do you see a paragraph there under the rule which says detainees who have been seen by the triage nurse and require or request to see a doctor subject to their consent will be seen on his/her next visit. Detainees will see a doctor in any such event within 24 hours of admission. There is also provision for a more immediate response from the doctor at the request of the senior nurse on duty if clinically indicated. That, again, seems to suggest that a detained person will see a doctor within 24 hours, firstly, if the nurse thinks they need to, if the nurse thinks they require it, or secondly, if they request it. Would you agree?
Yes.
Which clearly doesn't, as we've just been through, accurately reflect the rule that every detained person shall see the doctor within 24 hours.
No.
So that makes this G4S policy inadequate at the time. Would you agree?
I think that the following of the rule is what is inadequate, or the failure to follow the rule is what is inadequate.
And this policy encourages that failure.
Yes, and I think, again, it sort of underlines the fact that the understanding of why these rules are here in the first place seems to historically have been lost along the way.
Yes.
So people don't, at the healthcare end, seem to know what they're doing, why they're doing it on each point of contact with the detained person.
Yes. Thank you. You can take that down. Thank you. I want to come on then to look at Rule 35 itself in some more detail. Can we first deal with training?
Yes.
You mention in your original report, and I can give you the references if you need them, but perhaps just let's see if we don't need to turn to it first of all. There's no specific training regarding the identification of victims of torture in medical school or in a GP's vocational training, is there?
Not that I haven't been in GP training for a very long time, but there certainly wasn't any exposure to anything like that when I was a GP trainee or medical student.
No, you wouldn't necessarily expect there to be, because it's quite a specific area,
Yes.
isn't it?
Yeah.
But if someone's working as a GP in an immigration removal centre where that type of population is very prevalent, you would expect there to be some training provided for them specifically in relation to this area.
In my experience, and having spent a fair bit of time talking to GP trainees and medical students alike, you tend to find that there are some enthusiastic people who will come and shadow, or even do an elective, as I had recently in HMP Cardiff for a couple of weeks, to expose themselves to that environment because they're interested in the patient group. But it's not something that's delivered to everybody.
No, nor indeed everybody who works in the particular type of setting.
No.
There seems to be a lack of availability of training in this type of area.
Yes.
We heard that organisations such as Freedom from Torture have provided some training. Of course, they are charitable organisations who, in your view, should be providing training on this type of area to those who are working in IRCs?
Well, ultimately, I think it's the responsibility of the Home Office. But I appreciate that when I say that, they're not necessarily medically led, from what I understand or what I can see. So I think if they were to be responsible for that training, it would need to have the support of subject matter experts, clinical experts who can help deliver that training, speaking, if you like, doctor to doctor, doctor to nurse, and those other people who are doing the work at the immigration removal centre, so that they can fully understand the implications of all of the different components of the training.
Yes. If we look at, please, HOM 002581, please, on screen. This is effectively a slides PowerPoint presentation for GP training dated October 2015 on Detention Centre Rule 35. I think you looked at this in order to prepare your reports. If we just flick through it, perhaps briefly, if we can go through. It was clearly provided by the Home Office, as indeed the logo at the bottom suggests, and those people were involved in the provision of it. If we carry on through, please. It deals with then the three limbs of Rule 35, and over the page, please. And it deals with the DSO, which contains the templates for completing Rule 35 reports. Was that your understanding?
Yes.
Going through then, it outlines the purpose of the rule, and as we see on screen, to ensure that particularly vulnerable detainees are brought to the attention of Home Office caseworkers with direct responsibility for authorising, maintaining and reviewing detention. And if we carry on, please. It deals with the Home Office's policy that persons with independent evidence of torture are normally regarded as unsuitable for detention other than in very exceptional circumstances. And then it deals with Rule 35(3), the limb of the rule dealing with where someone has evidence or has made a disclosure that they may have been a victim of torture in the past. It seems then thereafter to focus very much on Rule 35(3). Would you agree?
Yes.
It covers, as we saw at the beginning, very briefly the three limbs of the rule, but then the rest of the presentation is really only on Rule 35(3). Is that adequate in your view?
Well, obviously I wasn't there at the presentation, so I don't know what was said verbally, but I think the three limbs need to be taken in the round. They need to be taken together and collectively, and a focus on just one of the limbs isn't sufficient. It just doesn't create the level of safeguarding that I think was originally intended by the rules.
Yeah. The training doesn't cover the interaction with ACDT or food and fluid refusal. Is that an omission in your view?
Unless it was said verbally, it's certainly not indicated on the slides that it was discussed, then I absolutely feel that all of those things that you've mentioned, and no doubt some other things, interact or should interact with the three limbs of the rules as they come up.
Including perhaps the use of force to prevent self-harm,
yes,
or suicide attempts.
Absolutely.
You say in your original report at paragraph 6.1.3.5 that there's no evidence of a comprehensive approach to the induction and training of new staff prior to the commencement of their work in Brook House. Is that right?
I have seen evidence of induction. It doesn't seem to go to the level of detail that would appear to be necessary for the safeguarding of detained persons in relation specifically around Rule 34, Rule 35,
yes,
and where those things should interact with these other things that may happen along a detained person's journey, as you've just mentioned.
Yes, so there should be, in your view, a more comprehensive approach to the induction and training of new staff in that regard.
Yes.
You came to the conclusion in your first report and indeed in your supplemental report that there was evidence of inadequate training of healthcare staff. Does that remain your view, having seen all the other evidence?
Yes.
There effectively was a lack of policies, you say, in your reports. What policies in particular would you have expected to see that you didn't?
Well, I think particularly around Rule 34 and Rule 35, if I was in a position of responsibility, I'd want to make sure that my staff understood why they're doing a particular task and what the outputs of that are, in order to ensure that they were being followed through. And you would need a policy to explain that, rather than just saying you're going to do a screening within 2 hours and you're going to book an appointment with a GP. You would need to have policies to explain what to do at each point. So, in other words, if you discover within 2 hour screening by the nurse that somebody is declared that they have a history of being tortured, then you know that you are referring them to the GP to be seen in order to consider Rule 35(3) and potentially Rule 35(1) or 2 if there are other issues that are arising from that. And I've seen nothing that explains it with that level of clarity.
Yes. You commented also that where there were policies, they weren't supported by bespoke training. Is that what we've just discussed, that the training on Rule 35 just wasn't sufficiently clear?
It wasn't sufficiently clear, and I recognise, in recruitment and retention in immigration removal centres and prisons, for that matter, is very difficult, and you get a high number of staff turnover. So over time you can lose an understanding of certain things and why you're doing it. And so I think ongoing training, refresher training, and a collective understanding is essential in order not to lose the underlying purpose of these particular tasks.
Yes. You also commented that where there was bespoke training, it wasn't provided regularly enough. Is that right? Did that also relate to Rule 35?
It doesn't appear to be, yes.
So there was limited training, limited people received it on a fairly ad hoc basis, and it wasn't recurring. All of those serious deficiencies.
And what appears to be a lack of understanding about it all in general in the round. I think from what I've seen so far, if there is a lack of understanding, it's impossible to train or create the policies or effectively take into account the relevant safeguards that you're trying to pursue.
Yes. So the GPs who were working in Brook House in 2017 and indeed now have received inadequate training, in your view, on Rule 35 and the adults at risk policy in terms of being able to carry out their obligations?
They appear to have an inadequate understanding of those rules.
In those circumstances, is it appropriate that those GPs are training other GPs in how to do Rule 35 reports?
No.
We'll come to it in more detail later, but you've also concluded that in the relevant period, around 3/4 of the Rule 35 reports that you've seen were inadequate for one reason or another. Is that right?
Yes.
Those were carried out by Dr. Uzarali and Dr. Chowdhury, still working in Brook House at the moment and training other GPs in how to do Rule 35 reports. Is that of itself a serious concern?
Yes. You say at paragraph 6.2.4.5 of your original report that in relation to Rule 35(3) reports, which were predominantly the reports carried out in 2017 and indeed thereafter, that the section 6, which is the conclusions section, the assessment of impact of ongoing detention there is difficult in the absence of specific training. We've dealt with the fact that there wasn't particularly specific training about that. What in particular makes that assessment difficult in the absence of training? Again, it goes back to understanding what is the reason for relaying this information to the Home Office. In fact, it appears that the priority around Section 6 within Rule 35(3) reports focused on the presence of torture and the history that had been provided rather than the impact of detention. So almost all of the reports that I viewed during the relevant period made no comment in regard to ongoing detention when it clearly asks for that specifically. And I can understand from the Home Office's perspective that they would want to see that particular information because they're considering review of detention based on the Rule 35(3) being provided to them at that point in time.
Yes. You also mention in relation to other types of training, so for example that compassion fatigue and desensitisation is common in a secure setting and it's difficult to eradicate. We've not seen any evidence demonstrating a proactive approach to training addressing those issues. Is that right?
No, and I'm not an expert in the area, but unfortunately I've lived and breathed it over the last 15 years in the prison environment, and it's all too easy to become desensitised to some pretty shocking things that you see on a regular basis. So over that period of time, you need to keep your clinical acumen up and your awareness around and your ability to relate to patients at its top level because you're dealing with such complexity.
And you haven't seen any evidence of such training or support in relation to Brook House?
No.
You make some recommendations about training in your reports, and you say, for example, that trauma-informed care training for both custodial and healthcare staff would be beneficial for raising awareness from the perspective of detained persons and help to provide a better understanding of their needs. Is that right?
Yes.
And that's particularly so in a population that where past trauma is particularly prevalent.
Absolutely.
In relation to policies, then, you say that the suite of healthcare policies that you were provided with in place during the relevant period appeared to be relatively basic, and you weren't able to identify a system for their regular review and revision. There needs to be an appropriately resourced mechanism by which policies in place are periodically reviewed and updated, and where appropriate, new policies are developed. Is that right?
Yes.
You also say it's essential to ensure that healthcare staff are routinely provided with sufficient time and resource for the improved education and training in respect of the awareness of and use of both extant and new policies. Did there seem to be sufficient time and resource dedicated to that in Brook House?
Not that I've seen, and I think the key here is that policies need to be updated in line with things that we learn, whether guidance changes or we've learned from significant events, and you know, much of this inquiry is arguably focused on significant events, but I haven't seen any learning as a consequence of those things or updates in regard to the policies and learning that's been acquired for the team's perspective in response to those things.
Yes, and you also say it's essential that new staff are provided with an appropriate period of induction in order to be familiar with the relevant policies and procedures in place.
Provided it's given by people with a good understanding.
Yes, and the policies themselves are adequate.
Yes.
I just want to look then at some specifics about Rule 35. So in respect to Rule 35, Dr. Uzarali gave some evidence that during the relevant period, allocation for Rule 35 assessments were one appointment a day. Is that adequate in your view?
Well, I don't know the volume of people coming through on a daily basis. I appreciate it would probably be quite variable, and there may be times when there are lots of people coming through, but to allocate one appointment per day does seem on the low side to me, especially if you had two people that came in the night before who had particular needs. Then how do you prioritise one over another? What do you do about other clinical duties, and how do you defer or deflect those so that you can deal with the primary issue here about safeguarding this particular person's needs?
So if there's a need for more than one person to have a Rule 35 assessment in a day, it effectively means there will be delays in everyone else's. Yeah,
or delays to other components of the healthcare provision, whether that be seeing it could be anything that you could be seeing as a GP in an immigration removal, and I can imagine from a GP's perspective it might range anything from mental health to physical health, acute things and long-term conditions as well. So I can see the conflict, and having listened to Dr. Uzarali's evidence, I can see the conflict between providing the safeguarding priority over the primary care delivery. But as I say, I think the emphasis is misplaced here, that actually the safeguarding mechanisms should take priority, as I said earlier.
Yes, and they weren't, which was leading to those delays in those assessments.
Yes.
While the person who's had the delay remains in detention because they haven't been assessed as they should, partly because if one appointment only is being offered a day, which appears to be a resourcing issue, the Home Office hasn't had a chance to review their detention, and they therefore remain in detention and exposed to likely harm. Is that right?
Yes, and I suppose from the Home Office's perspective, it must feel, a little bit out of sight, out of mind. They're not aware of anything at that particular point in time, so they're not necessarily going to be worried on behalf of that detained person. So until they get that notification formally to say, please review the detention of this person based on Rule 35, 1, 2 or 3, then they're not going to seek it out because they don't have any mechanism for doing that.
No, so it's the system that's been arranged.
Mm-hmm.
Which leads to those delays in identifying them and those safeguards failing.
Yes.
Can we look then specifically at Rule 35.3 reports and the deficiencies identified in those, because they really are the only reports that were effectively being created. The majority of them, as you've already confirmed, in the relevant period were inadequately completed in your view, and I think there were several reasons for that. Is that right?
Yes. Yeah.
So there was sometimes a failure to identify mental health consequences of torture, or failure to identify mental health symptoms. Was that right?
I think it focused too much specifically on torture and whether or not what was being relayed to the GP was torture or not, or something else. And I think it completely overlooked the fact that you have somebody relaying to something really quite significant that has happened to them in the vast majority of the Rule 35.3 reports that I've seen, that might in itself simply be a red flag to that person remaining in detention, full stop.
Yes. Was there a tendency to focus upon physical evidence of torture, such as scars and completing a body map?
I did see evidence that, and an understanding that not all forms of torture would necessarily lead to scarring. I did see evidence of a physical description of some scarring, but it was certainly, in my view, not done in an expert manner. And I'm not an expert in this area, but I have worked alongside experts who do know how to look at injuries and relate them to the history that's been provided in relation to that in the work that I've done with the CPT. So I have an understanding of how it's done. I'm not an expert in that area. My humble opinion on the basis of the Rule 35.3 reports that I've seen is that there is an inadequate relationship between the history that's being provided and the evidence that's then being accounted for in the examination.
And in particular, sometimes there was simply no mention of mental health symptoms at all.
Indeed.
And the mental health section effectively left blank.
Yes.
There was also, on occasions, a failure to address the impact of detention, even though the form directs the GP to do so.
Yes, as I've said, I think that was about 3/4 of the reports that I looked at didn't mention it at all.
Yes, and we'll come to that perhaps in a little more detail in a moment. But if mental health symptoms or mental health is not addressed at all, even in the presence of a history given of being a victim of torture, the result can be that the Home Office relies upon the absence of those concerns being raised from healthcare about those mental health symptoms as one of the key factors in maintaining detention. So the negative is relied upon in order to continue detention.
Yes, that would appear to be one of the factors, yes.
And that occurs even in the presence of an acceptance that there is evidence of the person being a victim of torture and therefore being a level 2 adult at risk. Is that right?
Indeed, yes.
So the task of this type of assessment, although it's only raising concerns, it is more than about simply documenting the physical. It's very important to address those mental health consequences of being a victim of torture.
Yes, and I can see a conflict here, both in terms of what I've seen in the records and in the oral evidence that I've seen from the GPs, that it appears that there is a divergence between mental health in its broadest sense versus severe enduring mental health. And in a way, it appears that the GP's perspective is that it's more towards the severe enduring mental health, and therefore if you happen to have a low level, let's say low level minor anxiety or depression or an undiagnosed post-traumatic stress disorder, that doesn't qualify in some way.
Yes, and we know those conditions are very prevalent in the IRC's population, particularly amongst victims of torture.
Yes.
So relying upon the absence of, for example, severe enduring mental illness such as psychotic illness doesn't address those concerns, does it?
No, and it doesn't relay the risk to the Home Office that actually somebody has a known issue.
Yes.
Because no matter how minor.
Yes, because psychotic symptoms aren't a core diagnostic of or features of PTSD, depression and anxiety, but as we've said, those conditions are very prevalent in the IRC population.
Yeah.
So an absence of that type of psychotic symptoms or severe enduring mental health can't be taken as an indicator that harm is less likely in detention, can it?
No, and I can see the conflict in the GP's mind. As a GP, I've looked after people both inside and outside of prison with, a huge variety of different mental health issues, whether it be, something simple and more common like anxiety and depression that we manage in primary care versus those people who I think are acutely unwell and need referral to a specialist team. Equally, when those people have been referred for their bipolar disorder or their, psychosis, and they come back to me, I'm still responsible for looking after them. So I can see where there may be a divergence there in the GP's mind. Well, this is something I see outside, and therefore I can manage it in here.
Yes.
As not being necessarily something they want to report or advise the Home Office of its presence.
Yes, even though they should be.
Even though they should be, yes.
You identified that there didn't seem to be any system of feedback or review in relation to reports that were completed. Is that right?
From the Home Office?
From the Home Office.
Yeah, absolutely. I would have expected to see something around the quality assurance, and indeed I didn't find anything apart from Insure's reports that really talked about this in any detail. In terms of numbers and what the outcome for those reports was. So I was quite surprised by that, really.
There should be such a
yes,
system.
I think so, absolutely.
And it's important that it's systemic, as opposed to individual caseworkers receiving individual reports, coming to their own conclusion that they're not adequate, and simply ad hoc informally going back to the IRC and saying, well, what about this?
So again, I think the key here would be in around, and I don't wish any disrespect to the caseworkers in the Home Office, but if they're not medically qualified or trained, how can they challenge the information that's in there? They can certainly ask for more information.
Yes, they could identify, I suppose, where, for example, something hasn't been even mentioned, such as mental health consequences of being a victim of torture or the impact of detention. But there didn't seem to be any system for doing so. It would only have been ad hoc.
Yes, yes.
And we know detention was indeed maintained, given the Home Office's reliance upon the absence of such recordings, suggesting that even on an ad hoc basis they weren't going back to challenge the absence of that information.
Correct.
There's clearly then, if there's no system for feedback and review, no identification of training needs or the reasons for inadequate responses, is there?
No. And
there should be.
Absolutely. It seems that the system that's in place, and having listened to the oral evidence, has taken its own trajectory and come to its own conclusion in terms of how it's managed, and that seems to be a fairly unilateral position rather than something that's been guided by a feedback process or a quality assurance process.
Yes. We've touched upon the failure to consider the impact of detention, which you said was present in around 3/4 of the Rule 35(3) reports that you looked at from the relevant period. So in those reports, the doctor had generally not conveyed any understanding of how past history of torture exposes a detained person to risk of harm or deterioration in detention. Is that right?
Yeah, I mean, the only other thing I would say is that if you're filling in a Rule 35(3) report and the person has had a history of torture, that in itself should also bring about a review of detention in and of itself. Whether or not the detained person's being managed in the detention setting or is coping in the detention setting really shouldn't be taken into account in a way. I mean, it may be of some reassurance to the Home Office temporarily, but it shouldn't be I'm trying to think of the right word here, a permission to continue detention indeterminately.
Yes.
And as we've heard, it's indeterminate at the moment in that sense.
And because there is an understanding from the research and literature on the subject that victims of torture are particularly vulnerable to suffering from harm in detention.
Yes. And sorry, just to go back to that point, I think I can appreciate from the Home Office's perspective, if you receive some information saying this person has been a victim of torture, you may need to go away, I appreciate, and do other things, and that may take some time. But if you haven't been given all of the information, or you've been in effect reassured by the absence of the information, or reassured by the fact that the person is being managed in detention, then it seems to take it takes the pressure off them in terms of reviewing that detention. That's how it seems to be to me.
And the Home Office were relying upon those factors to maintain detention?
It would appear so, yes.
And that in and of itself is a failure in the system of safeguards, isn't it?
Absolutely, yes.
So we've dealt with the fact that you've identified that there was no suitable mechanism for the quality assurance and quality improvement activities that would be necessary for ensuring that the Rule 35 processes were fit for purpose. I think you also identified that there wasn't any specific system in place for the re-evaluation of detained persons who have been identified as possible victims of torture in order to ascertain whether ongoing detention was indeed having a negative impact upon them. Is that right?
Yeah, nothing that I could see indicated that people were taking that level of responsibility over somebody who was declared that they are a victim of torture, no.
So there's no quality assurance of the Rule 35 report itself. And then there was also no system for re-evaluating that person who had been assessed as to be a victim of torture to assess the impact of their detention.
It was a wait-and-see approach.
Yes. There's still no oversight mechanism in the Home Office for the quality of reports being done. Is that your understanding?
To my understanding, yeah.
That's clearly a concern given how many you've identified as being inadequate.
And the number of years over which this has clearly come to bear. So, yes, 100%.
Yes. There's also apparently no oversight of the reasons why so many Rule 35 reports received by the Home Office don't lead to release of the detained person. Is that also a concern?
It is a concern. I don't really have a good understanding of that. I don't know what the pressures are from the Home Office's perspective. I would love to explore that in more detail and have an understanding of that, because it might help in terms of that training. I think as we go back to that, why are you doing this? Why do you need to do this? Why do you need to relay this information to the Home Office? Is it down to that we have seen so few people released from detention on the basis of those reports? I don't have the answers to those questions, and I don't know what the other pressures are in terms of their maintaining detention.
Yes. Dr. Bingham gave some evidence that clearly the reasons for missing the safeguard are not that there's a lack of clarity in the form, at least, but that it's just not being done, first of all, and then that there's no... as we've just established, there's no oversight or feedback mechanism and no quality assurance system in order to identify any of those factors.
Indeed.
That really seems to be a systemic problem, doesn't it, as opposed to an individual one with individuals filling in the forms.
As well as the understanding aspect of it, what are the human rights and the legal aspects of this and the rules and why they've been created in the first place. And I think that, that's a foundation that is clearly missing. Yes.
If we can move on then to the other limbs of the rule, other than Rule 35.3, you deal with those in both of your reports, but in your supplemental report at pages 29 to 30, you say, for example, that your understanding of the detention centre rules is that where there's an apparent deterioration of a detained person's health as a result of ongoing detention, there ought to be a Rule 35.1 report. Is that right?
Yes.
And in relation to Rule 35.2, that's the limb that deals with a medical practitioner having a suspicion of suicidal intentions on the part of a detained person.
Yes.
You say in your supplemental report that one of the aspects highlighted by the case studies is the apparent disconnect between the information known by healthcare staff and their ability to ensure a review by a medical practitioner was both timely and that it prompted the provision of a Rule 35.1 or a Rule 35.2 report where appropriate, particularly where there'd been an apparent deterioration in the detained person's mental health or there'd been an episode of self-harm or attempted suicide. Is that right?
Yes.
So these things were being reported from your review of some of the records to various members of the healthcare staff, but they simply just weren't leading to reports under these two limbs.
No, they weren't.
You go on to say there are several issues arising from these case studies. Firstly, it appears that there was no system in place for automatic review of a detained person where there was a self-harm, suicide attempt or an apparent deterioration. Is that right?
That's right.
So in those circumstances, which clearly, in your view, would meet the threshold of a Rule 35.1 report, a Rule 35.1 report simply wasn't being done.
No, and I think it appears that it was almost left to chance as to whether or not the doctor may have seen them, because of course it's them that has to make the report. So there certainly doesn't seem to have been any specific system in place that called for that timely, prompt review for the need for writing one of those additional limbs.
And the referral on to the GP, who, as you say, is the only person who can actually complete them.
Yes.
You say, secondly, it appears that when the medical practitioner, the GP, was asked to review cases where there was self-harm, a suicide attempt or an apparent deterioration, there was no systematic approach to the use of Rule 35.1 or Rule 35.2 reports in order to notify the Home Office of these changes in presentation. Is that right?
That's right.
So even where the GPs were seeing them, in the presence of self-harm incidents or suicide attempts or apparent deterioration, particularly, for example, in their mental health, a GP, it simply wasn't in the GP's practice triggering those reports to be completed when it should have done.
No.
That you say, thirdly, there does not appear to have been any mechanism by which the detained person's circumstances were systematically reviewed by the GP in order to consider whether or not their condition had changed over time and whether the detention was having an impact. Is that right?
Yes, and I think the key here is that if it was the case that you had identified somebody with particular vulnerabilities and you knew that either the Home Office was still in a position of making a decision or had made a decision that the detention should continue, clearly, while that person is still in your care, you would want to have a system in place in order to detect that deterioration so that you could then follow that initial information transfer to the Home Office that this person is now, there's an additional problem you need to know about.
Because they remain vulnerable.
Because they remain vulnerable, and in fact they may deteriorate or may be deteriorating. The rate at which they're deteriorating is clearly important to consider. Not essential, but it's important to consider, and so you'd want to relay all of that information to the Home Office, because ultimately, they are responsible for reviewing detention.
And there didn't appear to be any systemic provision for review over a period of time.
No.
It appeared that when Rule 35.3 reports were done, there was a practice of not completing any further Rule 35 reports, even if a detainee asked for one. Was that your understanding?
In terms of repeating a Rule 35.3?
In terms of using the limbs under 1 and 2, because there had been a Rule 35.3 report in place. There appears to have been a practice that if there had been a Rule 35.3 report, even where the thresholds for triggering the other two limbs occurred, the reports weren't being done.
No, they weren't, no.
And of course, simply because one has a Rule 35.3 report doesn't preclude having one at a later time under Rules 35.1 and 2, does it?
No, it doesn't.
Indeed, those reports should be being completed if the circumstances are appropriate, even if a Rule 35.3 report has previously been sent to the Home Office.
Indeed.
You conclude effectively that, in my opinion, the material provided indicates that there was a lack of clarity on the part of GPs as to the use of Rule 35.1 and Rule 35.2 reports during the relevant period. And you say, in my view, this may have been in part as a result of a failure of the healthcare staff to trigger the review at the earliest opportunity. So that's the referrals from other members of healthcare staff to GPs. So it's failing at that level initially.
Yes.
And then also have been partly because the GPs were not considering the provision of these reports when the opportunity arose during the relevant period. So it failed at that second stage also at the GP level.
It did, and I think we heard that the custom and practice, as I say, almost unilaterally decided that they weren't going to use those particular limbs or hadn't needed to because there were other mechanisms, or that there was duplication in having written a Rule 35.3 report that meant that writing Rule 35.1 or 2 was apparently unnecessary or appeared to be unnecessary.
Yes. You say, as a result, it is my view that these issues contributed to an inadequate use of the system and would have led to delays or a failure in the notification of these issues to the Home Office.
Yes.
The reasons the failures to complete Rule 35.1 and 2 reports is so concerning is that, first, the Home Office is not notified of someone who is at risk of suicide or deteriorating in detention. Do you agree?
Yes.
But also, and perhaps more importantly, secondly, that the person remains in detention for the risk potentially to be realised. Is that right?
Yes.
In other words, the person remains in detention for harm actually to be caused to them.
It seems completely counterintuitive when you look at it. Without those safeguards being used to their full force, if you like, at the earliest opportunity, then it appears that that is the only consequence, that people are likely to come to more harm.
Yes. And Rule 35(1), as we've established when we looked at the rule, doesn't require actual harm, does it?
No.
It doesn't require harm to already have been caused. It's looking at a likelihood of harm.
Yeah, and I go back to the sort of conflict here. This is one of those other areas, and I can see that predicting the likelihood of harm is being very difficult for a GP in this type of scenario. I think we're used to predicting risk around coronary heart disease and things like that because we have tools to assist us. But I also think the word likely is unhelpful here because it does deflect you away from the issue, which is that you have a vulnerable person in front of you. Whether or not they're likely to be of harm is a secondary matter, in effect.
And they're likely to be at harm by very impact of the fact that they're vulnerable.
Yes.
Yes, which is what the risk indicators in the adult at risk policy is designed to identify.
Yes.
So if there are those identifiable risks posed to the person of harm by remaining in detention, the doctor should be notifying the Home Office, which is the body that has the opportunity to review that detention, and they need to do that immediately so that that harm is not realised.
Or minimised, yes.
Yes. They shouldn't certainly be waiting to see if the person does come to harm in detention.
No.
In practice, that clearly wasn't the way it was working. It seemed that it was only in quite extreme cases of harm already having been caused that were triggering a Rule 35(1) report. Would you agree with that?
It appeared, I think the Rule 35(1) reports that I looked at appeared to be, I'm not even sure they were connected in a way. They appeared to be more detecting a severe mental health problem, so it was more about the threshold of the use of the Rule 35(1) rather than it necessarily being a consequence of the detention. It was whether I can not manage this person in detention, therefore
Yes.
a Rule 35(1). So I don't think there didn't appear to be a link in the mind of the GPs that I'll use a Rule 35(1) because there's deterioration as a result of their vulnerability.
Yes.
It was because they met a particular threshold in relation to the severity of their mental health problem.
Yes, so I as a GP now can't manage them in detention, so I best write a Rule 35(1) report.
Yes.
And that certainly doesn't fit with the adults at risk policy and the requirements of the rule to identify risk and not actual harm to the Home Office, does it?
Ask that question again for me.
Sorry, that practice
Yeah.
doesn't fit with what the adults at risk policy is designed to do and the requirement of the rule to identify
No.
risk and not actual harm.
No.
Instead, there was effectively a resort to managing those types of detainees on ACDTs, is that right?
Or not at all.
Or not at all, yes. Indeed.
Yeah.
Sandra Calver accepted in her evidence that the lack of Rule 35(1) and 2 reports in the presence of a high number of open ACDTs, some involving indeed constant observation, which she said indicated a high risk of suicide, indicated that too high a threshold was being applied and that there was a failure in the safeguards. You'd agree with her, presumably?
Yeah, I was quite shocked when I saw the number of ACDTs that had been opened, and obviously when you take that in relation to the number of Rule 35(1)s and the absence of Rule 35(2), it's shocking.
Yeah. In your supplemental report, you said that, as indeed you'd outlined in your original report, the material provided to you indicated that there were only 2 Rule 35(1) reports in the relevant period and no Rule 35(2) reports in the relevant period. and you said you'd not been provided with a clear explanation as to the reasons why those particular reports were not utilised. In your view, the case studies indicated that the threshold for their use had been met according to your understanding of the detention centre rules. Does that remain your view?
That remains my view.
You looked in particular at the case of D801, where a Rule 35.1 report was provided, but there appeared to be a delay in the completion of the report and the notifying of the Home Office utilising that mechanism. We'll come to his case in a bit more detail a little later, but that appeared to be an example where there had been quite significant harm actually caused before a Rule 35.1 report was done. Would you agree? You also said that with particular reference to the case studies for D1914, D687 and D1527, the use of Rule 35.1 and Rule 35.2 does not appear to have been undertaken when there was an apparent deterioration in the detained person's condition. Again, we'll come to them in some more detail later, but does that remain your view?
Yes.
Dr. Uzarali gave some evidence about the reason for the lack of Rule 35.1 reports, and in answer to the question, what is the explanation for there only being 8 Rule 35.1 reports in 2017, he said, because I think the management of that patient, I would assume because I haven't got all of those documents, but actually those patients were able to be managed within that detention environment, and therefore it wasn't felt. And that was the threshold that was in the Rule 35 documents about, can you manage these patients in? And he said, if you're saying, I asked, so you felt it was appropriate not to write Rule 35.1 reports where their health could be managed in detention? And he said, I felt that was certainly an aspect to it. And that's what you've just been describing, that the threshold seemed to be, are we incapable of satisfactorily managing them in detention? Not, is there a likely deterioration?
Yes.
And that practice seems to have developed despite Shaw's recommendations to do away with the criteria of satisfactory management in detention, and the fact that that phrasing doesn't form any part of the adults at risk policy to consider that. Is that right?
Yeah, absolutely.
And so decisions were being made to manage vulnerable detainees in detention instead of applying the safeguard under Rule 35.1 as it should have been applied.
Yes, and I think, as I said earlier, this seems to have been a unilateral position that was reached over time, and possibly for a number of reasons. Obviously, I haven't been able to really get to the bottom of why that has been the custom and practice in place, but it certainly seems to contribute to an ongoing lack of an understanding of what those safeguarding mechanisms are trying to do and trying to achieve, and the priority that needs to be placed upon them in order to, deliver effective safeguards.
Yes, thank you. Chair, that might be an appropriate time to pause for a break. Can I say 22, please?
Thank you, Ms Simcoe. Thank you, Dr. Howard.
Thank you. Thank you. Doctor, I just want to look at some further aspects of this idea of managing ill health, and particularly mental ill health in detention. In terms of the profile of detainees in an immigration removal centre, we've touched on this as well. A high proportion of detainees have clinically significant levels of depression, PTSD and anxiety. Is that right?
That's my understanding. I mean, I've never seen anything in respect of the current population or during the relevant period that gives us a definition of the prevalence of those issues. I'm aware of the research that's been referenced that gives an indication of that, but nothing hard and fast that describes the population as it is.
PTSD is frequently linked with a history of torture or other forms of serious ill treatment. Would you agree with that?
As I understand it, yes.
Yeah. Dr. Bingham gave evidence that for a victim of torture, experiencing a re-triggering of symptoms of trauma is a source of extreme distress and suffering, and that flashbacks are not just something that happens in passing, but it's really a re-experiencing of torture. For that person, it's as if they're being tortured again. Would you agree with that?
I'm not an expert. I'm not a psychiatrist. I'm not an expert in this area, but I can appreciate what she's saying. Yes.
Professor Katona, in his witness statement at paragraphs 95 to 97, said that someone who suffers from severe depression but is left in detention is likely to suffer from further loss of hope or motivation and may develop or worsen risks of suicide and self-harm. Would you agree with that?
Yes.
People suffering from PTSD may go on to suffer secondary psychosis whilst in detention owing to the stresses of being there and re-traumatisation. Would you agree with that?
I can see that, yes.
We heard some evidence from mental health nurse Karen Churcher that Brook House was not an environment where it was possible or appropriate to give trauma-focused therapy. Were you aware of that?
The evidence, yes, that she gave, yes, I'm aware of that, yes.
So certainly trauma-focused therapy wasn't being provided in Brook House in 2017.
I didn't see any evidence of that, no.
Sandra Calver gave evidence that it's not possible to provide CBT in detention, that the detainees don't have access to a full range of psychiatric treatment in Brook House, and that detention centres are not appropriate therapeutic environments to promote recovery from mental ill health due to the nature of the environment and the lack of specialist mental health treatment resources. That also accords with the Royal College of Psychiatrists position statement on the issue. Do you agree that an IRC is not such an environment?
Certainly not the way it's configured currently. It's not a therapeutic environment, no.
Would you agree that segregation, in particular, can be clinically harmful and may make things worse for someone with existing depression or severe anxiety, PTSD or suicidal ideation?
I can see that. I can also see, and in my experience working on the prison side, segregation sometimes for some people has in a way a protective factor, because it takes them away from an environment where they feel threatened. So it can give a bit of a closer eye on things. But there are two sides to every sort of evaluation of that. But I can certainly see in relation to vulnerable detainees, it absolutely could be an exacerbation or an increased exacerbation of their underlying issues.
Yes. Dr. Bingham and Dr. Patterson are of the view that segregation in particular is not an appropriate setting to accommodate vulnerable detainees with mental illness or at risk of self-harm. Would you agree with that?
Not as a general rule. I agree.
If someone needs to be segregated, in other words, to go to the care and separation unit, the CSU, or to be managed on E-Wing under Rule 40, which deals with removal from association, then they must be very unwell, mustn't they?
I would hope so, yes.
And that should require a report under Rule 35.1 at
Yes.
least, or potentially under Rule 35.2.
Yes.
It requires a consideration of whether they're suitable for detention.
Yes.
Do you agree that segregation should be a last resort?
Absolutely, yes, and yeah.
So the healthcare professionals involved all seem to agree that there's no real therapeutic intervention available, particularly for mental ill health in detention. Would you agree with that?
Yes.
Everything appeared to be centred on risk management, didn't it? We can look at certain aspects of that, but if the interventions aimed at dealing with mental ill health, self-harm and suicidal ideation are not therapeutically based, they were effectively in order to risk manage those behaviours. Would you agree?
They certainly didn't seem to be very detained person centric in terms of their needs.
There was a security focus.
Yeah, absolutely.
So if we look at certain aspects of that, the ACDT tool is used as a risk management tool. It tends not to prevent a deterioration in mental health and is certainly done with no GP input. Would you agree with that?
Yes.
Again, that appears to be a custodial risk management tool and not any type of clinical intervention. Is that right?
I agree.
Evidence from the healthcare professionals to the inquiry confirmed that E-Wing was used to manage distress behaviour, including self-harm and suicidal ideation, and certainly not for the primary purpose of providing treatment. Was that your understanding?
Yes, it seems to be done for the convenience of the staff and not for the benefit of the detained person.
Yes. High numbers of people removed from association informally and formally under Rules 40 and 42 to manage their self-harm or suffering from mental illness seem to be occurring. Did you see evidence of that in the records you looked at?
Yes, and I think also in response, for intoxicated people as well.
Yes, yeah. Indeed.
So segregation wasn't being used as a last resort. It was being used as a risk management custodial type of intervention. Was that your understanding of what was actually happening on the ground?
Yeah, I don't see the logic of the risk management part of it, because it feels like it was done almost as if there was nothing else to do, so therefore we will do X,
Yes.
which is to remove from association, rather than it didn't appear to have a finite or understood purpose to me.
No. And certainly Sandra Calver accepted that it wasn't always being used as a last resort. It was actually, as you say, in order to do something.
Yes.
And whilst on E-Wing and indeed the CSU, detainees were primarily being managed by detention staff with very little clinical input. Was that your understanding?
I didn't get a sense of any significant involvement of the clinical staff with the detained persons once they were in those aspects of Brook House. And that may be down to the fact that they weren't recording it in the clinical records, or that it wasn't happening. Either way, I didn't see the evidence that it was happening.
Yes. Clinical risk assessments weren't routinely done to screen for vulnerability when considering whether to use segregation. Sandra Calver accepted that. Was that your understanding?
Yes, indeed.
Should they have been?
I think it goes back to the steps, which are, am I detecting that somebody is vulnerable in this environment, and if I'm going to then place them somewhere that could be even more harmful, there needs to be a step in place there to screen for that additional impact.
Particularly where segregation may be positively harmful to someone who's
yes.
particularly vulnerable.
It's potentially additionally harmful or dissociating for that individual, potentially.
Yes.
As I said before, there are occasions when, for some people, it may prove to help relieve their anxiety about being on a busy wing, for example. But in the main, given the prevalence of the mental health issues that we see in this population, I would suggest that you need a robust additional step before the use of segregation in this group.
And there didn't appear to be one.
No.
Sandra Calver gave evidence that some people did indeed deteriorate mentally as a result of being on E-Wing. Was that your understanding
Yes.
as well?
Yeah.
So it seems that exactly what is of concern was indeed, there was evidence of it indeed happening.
Yes.
Given all of that evidence, would you agree that the system wasn't just inadequate because Rule 35 1 and 2 reports weren't being done, but also in several other quite serious respects.
Yes.
So the safeguards have effectively been set up structurally to fail because, as we've established, a Rule 34 compliant examination can't be done at the outset, and the Rule 35 process is therefore delayed. That's one aspect of a systemic failing.
They seem largely absent. I mean, they're there occasionally, but not routinely and not consistently.
Yes. And when it was applied to a person, Rule 35 wasn't being used effectively or indeed at all, as we've established. And ACDT certainly didn't lead to Rule 35 reports. Again, that's a systemic failing.
Correct.
Nor indeed did food and fluid refusal lead to consideration of a Rule 35 report. Again, a systemic failing, not just up to individuals.
Yeah, it appears that those sort of mechanisms went off down their own cul-de-sac and weren't connected back to those underlying safeguarding principles embodied within Rule 34 and Rule 35. And there, in my view, needs to be a connection between all of those things.
Yes. A disconnect, as you say. They seem to be operating in their own little silos.
Yes, absolutely.
But not as an overall consideration systemically in relation to vulnerability and the need to review detention.
No.
A practice we heard of using Part Cs to inform the Home Office of vulnerabilities or risks or incidents indeed had developed. And the difficulty with Part C being clearly that it doesn't require a review of detention by the Home Office. Is that right?
That's my understanding. I know that we heard evidence that it did occasionally apparently prompt review of detention. Whether that's true or not, I don't know. But nonetheless, it overlooks the founding principle that if you've got the rules, then those are the things that should be used in order to prompt the review of detention.
Indeed, and the importance of the safeguard is that it requires a response.
It requires a response.
It doesn't leave it up to the person receiving it.
No.
And the consequence of all of that was that a number of vulnerable detainees were left in detention when they were likely to be harmed by that detention.
Yes.
There, as we've just discussed, there were certainly no therapeutic ways to manage them if they became more unwell due to being in detention. ACDT wasn't a therapeutic intervention. There was limited psychological and psychiatric treatment available, no CBT, no trauma-based therapy. Again, a systemic problem.
Yes.
The only options really centred around risk management and containment, as we've said, segregation, management on the ACDT as a custodial risk management tool. Is that right?
Yes.
And those options may actually cause someone to deteriorate further.
Yes.
Even at that point, they weren't being identified for release under Rule 35. That's of significant concern.
Yes.
As we've heard, people who suffered from PTSD may be reliving their trauma as if it was happening again whilst in detention, so positively being harmed.
Yeah, absolutely.
And people with depression may be deteriorating, also becoming more hopeless and increasing their self-harm and suicide risk.
Yes.
Some indeed may have developed psychosis or psychotic symptoms or lost their mental capacity to make decisions about their care and treatment.
Indeed.
Is that right?
Yes.
And I think one example of that is D1275's case that you looked at briefly.
Yes.
The entire system in various respects then appears to be dysfunctional. Would you agree?
I would.
Could we look at then some of the individual cases? Want to look first at D801, and you considered his case at pages 40 to 48 of your supplemental report. He was someone whose detention began on the 1st of March 2017, and it was his second period of detention. After his first detention in 2015, which was also in Brook House, his mental health had deteriorated in the community, and he'd made 2 failed attempts at suicide. He'd been found disorientated and hanging on railings by the police on one occasion and brought to A&E. The Home Office, we know, were aware of those incidents because they had received an independent medical expert's report saying that detaining him again would cause him harm and cause deterioration, but he was nevertheless detained in March 2017. An ACDT was opened on his admission to Brook House on the 1st of March, and on the 2nd of March he was seen by Dr. Belder, who was the psychiatrist at Brook House, and he recommended a hospital transfer. Just pausing there, you're not a psychiatrist, you're a GP, but would the fact that a psychiatrist had recommended he be transferred to an inpatient psychiatric facility indicate that he was really very unwell?
Yes.
The hospital didn't accept his transfer on the 8th of March, but healthcare staff continued to be concerned about him and made entries in the records, for example, Sandra Calver on the 13th of March. And in your report, you criticised the lack of a Rule 35.1 report and a lack of a Rule 35.2 report in these circumstances. Is that right?
Yes.
He was being managed entirely on Ewing under an ACDT, and on the 19th of March 2017, he tied a ligature that appeared to be a suicide attempt. Again, at that stage, no Rule 35.1 or Rule 35.2 report was completed. In your view, should one or both of them have been completed?
Yes. I mean, I can't remember exactly what I've written in the paragraph, but I would have said one way or the other they should have been written in relation to that history.
Yes. He was seen by Dr. Belder on the 31st of March, who said explicitly that he was not fit to be detained at Brook House as he couldn't receive appropriate treatment. So he was still of the view that he needed treatment that couldn't be provided in Brook House. And during this time, D801 says to the inquiry that he was re-experiencing his torture from his home country. And he told an independent expert that he couldn't eat, he was just stayed inside his room, he didn't want to socialise with anyone, and the whole experience to him felt like walking on fire. So although he wasn't someone who was either physically assaulted by staff during this time nor verbally abused, leaving him in detention during this period for a total of 34 days caused him to suffer ill treatment because none of the safeguards that were meant to function to remove him from detention worked. Would you agree with that?
I would. It does bring up a couple of issues. One in relation to the psychiatrist apparently not being in a position to be able to do those Rule 35 reports themselves, or in a clear understanding that they couldn't do them, making sure that the GPs did undertake that assessment further in order to notify the Home Office of that particular issue.
Yes.
And it does, strikes me that this is a really good example of a complete inattention of the understanding of the purpose of the rules, and that there was an imperative to relay that information to the Home Office at the earliest opportunity, with the mechanism that would have meant that a review of detention was undertaken at that point in time.
Yes, at the earliest opportunity and then at every other opportunity.
And then at every other, yes. Fair.
And the fact that they didn't caused him harm.
Yes, I can see that.
We heard, and we've touched upon it, some evidence about a practice of completing Part C forms to the Home Office to indicate vulnerabilities or risk instead of using Rule 35 reports. That was a practice that appeared to have been at least approved by the Home Office, according to Sandra Calver. But the fundamental difference, as we've discussed, was that only Rule 35 requires the Home Office to review detention. Is that right?
That's my understanding.
So if healthcare had been given an impression by the Home Office that they were either encouraging or at least content to receive Part Cs instead of Rule 35s, that would be a misdirection by them, wouldn't it?
It would, and I didn't see any evidence that that was the case, which is to say that if a Part C was received by the Home Office that contained information that otherwise should have been on a Rule 35, 1, 2 or 3, that they should, meaning healthcare, should complete the relevant form. I didn't see anything to that effect.
No, and both Dr. Uzerali and Sandra Calver, as head of healthcare, gave evidence that they had never had concerns raised with them by the Home Office as to the lack of Rule 35, 1 or 2 reports. Would that be a concern?
It is a concern, yes, yeah.
Dr. Uzarali gave evidence that the reason for using Part C instead of Rule 35 reports was that it was a more dynamic way of informing the Home Office of concerns. They would get a response quicker. And in his experience, the receipt of a Part C would lead the Home Office to review detention and indeed release detainees, even though there's no statutory requirement of the Home Office to have done so. When Dr. Bingham gave evidence, she said that that wasn't a medical justice or her experience, and that Part Cs didn't lead to a review of detention. And indeed, D801 was a good example of that, because he had had 4 Part Cs completed in relation to his mental health and self-harm or suicide attempts during his period of detention in March 2017. And indeed, his detention had been maintained. Were you aware of that?
Yes, and I don't know that I've seen anything in the evidence, orally or written, that accords with Dr. Uzarali's evidence that he gave, that it was an effective mechanism.
Yes. Dr. Bingham gave evidence that there were also cases where there were concerns, but not only was Rule 35 not used, but no Part C was
Indeed,
completed
yes.
either. Is
Yes.
that also a concern?
Absolutely, yes. I mean, but we go back to Rule 35, 1, 2 and 3. Those limbs are there for a very good purpose, and I would rather they were used appropriately and accordingly,
Yes.
rather than what appears to be a fairly one-sided decision, unilateral decision, just to use Part C instead.
Yes. Rule 35 isn't optional.
No.
If we look then more specifically at Rule 35(2) reports, we know there were none in 2017 or indeed in the years thereafter. There were high numbers of ACDTs open in that period, in the relevant period in 2017. Suicidal detainees, we heard, were being managed on ACDTs using a constant watch indicating, as Sandra Calver accepted, a high risk of suicide.
Yes.
You'd agree with that?
Yes.
There seems to have been a complete disconnect, as you've described, between the ACDT system and the Rule 35 system, doesn't there?
Completely.
Open ACDTs, even where there was a constant watch,
Yes.
simply weren't provoking the consideration of either Rule 35(1) or Rule 35(2). And you've mentioned that in your supplemental report. That's, again, a significant concern.
It is, and I've had no explanation for that at all. I can't fathom why that might have come to be. It doesn't make any sense to me.
Yes. They could and should be linked.
Yes.
You recommended better training in that regard, is that right?
Again, having part of that is the founding understanding of why you're doing what you're being asked to do. Why do I need to fill in a Rule 35(2) report? It's because I'm being given information that makes me suspicious that I need to that this person's got a risk of self-harm or suicide, and I need to relay this to the Home Office.
Yes.
It seems obvious to me, and when I look at the material, it seems obvious.
Yes.
But for some reason, it wasn't happening.
It wasn't happening. And it's particularly so in circumstances where, as we've established, the ACDT was and is a custodial risk management tool and not one designed to give any therapeutic intervention. So it's not an alternative, is it?
No, it's not.
It's not a clinical tool, and it doesn't address the underlying causes of self-harm or suicidal ideation.
No, again, it would be as put by Dr. Bingham. You know, it is essentially in order to keep somebody safe. But if you have the Rule 35(2) alongside that whilst you're waiting for it, at least you can be reassured that you are keeping that person as safe as possible while asking for the review of detention.
Yes. So it's not an adequate response on its own, is it, to an episode of self-harm or a suicide attempt in circumstances where Rule 35 isn't being used?
No, and I guess this almost speaks back to that issue of desensitisation and normalisation, that my population is likely to do self-harm at this sort of level, and we will just manage it with an ACDT rather than considering our founding principles of what's embodied within the Rule 35.
Yes, and so you recommend a more robust approach to the system of education and training for both custodial staff and healthcare staff on ACDT, but also on Rule 35.
Yeah, I think there's an interesting point there, actually, which, I recognise that as the healthcare providers, you're often sitting in your clinical workspace, but, your detained persons are living on their wing and will know many of the custodial officers, so they, therefore, are an important link to be able to identify any concerns that they may have and relay them to the healthcare. So yes, if they see deterioration, that should be an important part of that process. You're sharing that duty of care.
Yes. Sandra Calver also accepted that the lack of Rule 35(2) reports indicated too high a threshold was being applied to complete the form. You'd agree with that?
100%.
And that the safeguards were therefore failing. Dr. Uzarali gave evidence that he still never completes Rule 35(2) reports, so it remains a significant concern, doesn't it?
Well, the threshold appears to be infinite, and that doesn't make sense to me because, as you say, even people with constant supervision at an immediate risk of threat to life or limb are still not having a Rule 35(2) report.
Yes. And again, we heard some evidence that the Home Office hasn't and still hasn't raised any concerns with either Dr. Uzarali or Sandra Calver, both still in post as the lead GP in Brook House and the head of healthcare. That appears to be a tacit approval of their non-use, doesn't it, by the Home Office?
I wouldn't like to say on behalf of the Home Office whether they approve of it, but as I indicated earlier, if they don't know about it, they can't deal with it. But it should raise questions, absolutely.
Yes, in circumstances where they know
yes.
they're not being completed.
Yes.
The safeguard isn't being applied.
Well, they don't necessarily know that they should be completed, but I think the complete absence of them should raise questions about, as we all know, there is a prevailing level of mental health issues and a level of self-harm here. The use of other mechanisms that the Home Office would be aware of should have raised questions as to why there was a complete absence of Rule 35(2).
And continues to be.
And continues to be, yes.
Can we look then at another case study, D1914? You discuss this case study at pages 23 to 30 of your supplemental report. You've also dealt with this case study in your original report, but just looking briefly at the details in relation to him. For example, on the 5th of July in 2017, D1914 was noted to have self-harmed by making cuts to his arms and neck and taken an overdose of his medication. And we saw the result of that act of self-harm on the panorama footage,
Yes.
which you'll be familiar with.
Yes.
And you say that whilst an ACDT was opened, there was no corresponding Rule 35(2) report apparently provided to the Home Office to notify them of this change in his circumstances, and additionally there was no Rule 35(1) report, either of his apparent deterioration on this occasion. And in your view, there should have been both a Rule 35(1) report and a Rule 35(2) report, or at least one or the other.
Yes.
On 13th of July 2017, Dr. Chowdhury completed a Part C, relaying his concerns to the Home Office of the risk of his condition worsening in detention, but notably, again, there was no Rule 35(1) report completed on that occasion, and there should have been.
Yes.
Subsequently, there was a Rule 35(1) report completed by Dr. Uzarali on the 17th of July, and you say that in relation to that, clearly that although a Rule 35(1) report was appropriate there, it should have happened earlier.
Much earlier, yes.
In your original report at paragraph 5.261, you dealt with some of the elements of in relation to this gentleman, his risk factors. He was someone who had a serious cardiac condition, having undergone double coronary artery bypass graft. He'd had some cardiac symptoms while he was in Brook House and some abnormal blood results, and he was awaiting a further cardiac procedure. He also had some mental health issues, and he, as we've just talked about, some episodes of serious self-harm or suicide attempts whilst he was in Brook House. So here there were multiple indicators to flag up his risk in detention, weren't there?
Yeah, yes.
You, as we've just dealt with, commented on the failure in his case to do a Rule 35(1) or indeed a Rule 35(2) report. He's someone who should have been alerted to the Home Office very early on, shouldn't he, really at the outset of detention, as someone not suitable to remain in detention. Would you agree?
I would agree. I think the challenge here, a little bit of that conflict that I spoke of earlier about the GP's sort of priority around the physical health, perhaps, particularly in this case, which is, can I manage a patient with these particular health issues? And I'm talking about his cardiac issues, and and there will be GPs across the country that manage these patients while they're in their homes, with having had coronary artery bypass grafting and be on this list of medications. It doesn't go in any way to speak of the particular vulnerabilities of this particular detained person, and I think that's the missing link here, which is,
Yes.
I can manage the physical health, and it's just a list of medications. So why couldn't I manage this person in the detained setting, without recognising the fact that that impact that we've spoken of is an additional pressure within the environment that you need to take into account, and doesn't appear to be taken into account, because the assumption is I can manage this physical health problem.
Yes, and particularly he should have been notified under Rule 35(1) because actual harm isn't required, only likelihood of harm is required, and he fulfilled those criteria at the outset, didn't he?
Again, as I say, I can see from a GP's perspective why you might think, well, actually, I can manage this. So I almost can't see the likelihood of harm. But then when you overlay that with his response to being controlled and contained in that environment, and his response to that, then you can clearly see where there is a conflict there.
Yes, and that's so all the more reason to do a Rule 35(1) report once he actually started to deteriorate.
Correct. Yes. And that wasn't given any thought.
No. He was getting certainly more agitated and frustrated by his detention, apparently, and his inability to access the treatment he required. That appears to have been induced by his very detention, doesn't it?
It does. I mean, I recognise also that there were occasions where he was taken to hospital and he self-discharged or didn't wait, etc. And, I can see that that's very difficult to know how to manage and what to do about that, because on the one hand, you're trying to progress his physical health, knowing that he's waiting for that further procedure to be done. How do you deal with that, when that person comes back from the hospital having not had that assessment or that review done? Rather than taking the view that it's difficult to articulate, but rather than taking the view that that's down to a deterioration, it's just taken a view as that that's how he is.
Yes, that he's deliberately...
And that it's deliberate, or that it's intentional, or there to frustrate the healthcare. And that's certainly how it comes across as being perceived by the healthcare staff.
Yes, Dr. Bingham gave some evidence about that he was an example of someone whose mental illness was essentially mischaracterised as refractory behaviour.
Yeah.
And he was seen as non-compliant, not unwell. Would you agree with that?
That's how he was characterised, yes. Yeah.
He was subject, for example, to a planned use of force to facilitate his removal. Again, seemed to be being treated as deliberately non-compliant and not vulnerable and unwell.
As I alluded to earlier, it seemed to be done for the convenience of the custodial staff and not for his or consideration of his issues.
Yes. On the 19th of April 2017, Healthcare were asked to confirm whether D1914 was fit to be detained and fit to fly in light of his emergency visit to hospital the previous day. In response, Dr. Chowdhury stated that D1914 was fit to travel and to be detained. Seemingly as a result of that letter, the Home Office filled in an airline risk assessment on the same day, leaving the section blank that stated, are there any known health issues requiring mitigating action? That's problematic, isn't it? It's of concern.
Yes.
No information was passed to the airline or to the officers tasked with the removal as to the fact that he had a serious heart condition and that stress may lead to a deterioration in that condition. He might even have a cardiac arrest.
I think the sort of the confounding issue here is that stress and the sort of enforced removal and flight. Looking at the CAA guidance, you can see that provided you meet certain criteria in relation to recent cardiac surgery, then technically you're fit to fly, and most GPs will be versed to looking at guidance like that in order to agree that their patient is fit to fly when they've had an operation not that long ago, or they have a particular condition, and that guidance is pretty straightforward. So you can see where the priority may have been placed on that component, without necessarily, as I say, looking at the overlying stress that is going to then impact upon the individual, especially given the history that we know of how he responds in stressful situations.
Yes. The use of force upon him was approved by Dr. Uzerali in a letter to the Home Office on the 27th of May 2017, and he stated, "The above detainee is fit to fly and fit for detention. He will need a medical escort due to the nature of his medical condition. I am happy for reasonable force to be used, brackets CNR, in order to facilitate the removal." Dr. Bingham gave some evidence that healthcare staff, which includes GPs, had an important safeguarding and monitoring role in relation to use of force. Would you agree?
Absolutely.
The first, in relation to safeguarding, then, is to raise concerns or contraindications to a planned use of force, reasons why you might not want to use a use of force.
Correct.
Is that right?
Yes.
The second, clearly, being to monitor any use of force that does occur and intervene if there were any concerns for the condition of or welfare of the detained person. Do you agree with that?
Yes.
In relation to the safeguarding role, then, it's important to raise concerns or contraindications when they're present, and not to positively approve or sanction a use of force. Is
The
that
doctor's role is definitely not to approve the use of force.
right? Which is what Dr. Uzerali did here.
He did.
That's completely inappropriate.
100% inappropriate. Unacceptable.
Sandra Calver gave evidence that she wasn't aware that the doctor was saying he was happy for reasonable force to be used, and that she would have been concerned if she'd known, because it wasn't for them to decide on force being used. And you'd agree with her?
Yes.
No concerns or contraindications were in fact raised here by Dr. Uzerali. As we see, he did the opposite in his letter. That was despite the fact that this was a use of force not to save his life, so to safeguard his immediate safety, but was to remove him, to facilitate his removal, which Dr. Uzerali accepted was a situation in which it wouldn't be in the best interests of the patient to have force used. Would you agree with that?
Say that for me again.
It wouldn't be in the best interest of a patient to have force used against them to facilitate their removal.
No.
Really, the only time it's in the best interest of a patient to have force used against them is to immediately save their life.
Yes, I see what you're saying, yes.
The letter Dr. Uzerali wrote also didn't contain any information about D1914's physical, medical condition or his mental vulnerabilities and self-harm. He said that was due to a non-medical person receiving it, and also to patient confidentiality. But the effect is of concern, isn't it? Because in approving a use of force, those receiving that letter don't have any of the indications of why a use of force might be a risk.
So I think there are two issues here. One that we've heard about from, I think it was Dr. Bingham, in relation to the sharing of information. And I have to say, what I don't know is whether there is an information sharing protocol that exists in order for the sharing of medical information. But nonetheless, the other issue is that it's quite possible to relay information about risks without necessarily revealing specific health information. Therefore, you're not necessarily breaching confidentiality. And of course, thirdly, as we've heard, you can always speak to the detained person and obtain their consent.
Yes, which wasn't done here, clearly.
Which appears not to have been done. So, given what I've seen here in relation to this case, it would have been possible, I think, to relay a concern, a significant concern, about the use of restraints in effecting what they needed to, rather than positively endorsing it.
Yes. Dr. Bingham was of the view that Dr. Usarali should have raised both his physical medical condition and his mental vulnerabilities and self-harm as concerns or contraindications to the use of force in D1914's case. Do you agree with her?
I do, because I think this is going to be a complex problem for a number of people to consider. How are we going to address this? And you can see with the underlying cardiac history and the additional stress of being forced onto a flight that, you know, a disaster could happen.
Yes.
And to not relay that in any way, shape or form is a failure as far as I can see.
Yes.
And ultimately could have led to a very, you know, serious incident or death.
Yes. Dr. Usarali said in evidence that he had considered his condition was stable. He later, on the 17th of July, in a Rule 35 report, set out his history of 2 myocardial infarctions, 2 coronary arterial bypasses, that he was currently awaiting a cardiac catheter ablation for abnormal cardiac rhythm, and that he had intermittently been complaining of chest, I think there's a word missing, I think, but of chest something during his stay, possibly chest symptoms or chest pain.
Chest pain, yeah.
And was recently sent to A&E as healthcare felt he had acutely deteriorated. He said in that report it is felt that he is a high-risk patient in view of his medical condition, and that though detention is not worsening his condition, the stress may trigger events that lead to another cardiac event. Would you agree with all of that?
I would. I suppose, firstly, why was that not considered earlier? I guess one possible explanation might be that you needed to see that deterioration in order to form a view. But nonetheless, I think it was considered far too late.
Yes.
And it wasn't certainly considered at the outset. One knew his medical history at the outset, therefore knowing what immigration detention is ultimately for and what it may lead to, that one needs to have those things in one's mind, i.e. enforced removal, control and restraint, etc. So you'd want to highlight those risks at the earliest opportunity,
Yes.
not at a late stage like this, and certainly not in conflict with previous statements that one had already made
Yes.
a month prior.
And Dr. Usarali would have known all of those factors when he wrote that letter on the 27th of May. He should have been considering that those things were a concern and a contraindication to the use of force,
Yes.
rather than saying he was happy for it to be used.
Yes.
In that Rule 35 report, in answer to the question what impact is detention or the conditions of detention having or likely to have on the detainee's health and why, Dr. Usarali referred to the history I've just given above and then said ongoing stress and the unstable nature of his cardiac condition put his health at risk. Is your view that his cardiac condition was unstable?
As I say, in terms of the physical health, from a GP's perspective, I can see how you could manage somebody in primary care just like this. If you add to it the additional stress of being in the immigration removal centre with the various things that may arise while you're in there, it is that's not taken into account.
Yes. And this was someone who was still awaiting a further cardiac procedure
Yeah.
and who had cardiac symptoms. Those don't tend to suggest a stability of condition, do they?
I wouldn't. Another way to put this is if I had a patient like this in the community and I knew they were waiting for a procedure, I wouldn't necessarily be worried about them suddenly deteriorating. And if they did, they know what they can do. They can phone 999, they can ring the surgery, and we can assess them and we can give them advice. But there isn't a necessarily overlying current of additional stress, which is there all the time. Clearly, if a patient like this came to me and said, I'd like to run a marathon,
Yes.
we would be having a different conversation.
Yes. Or I'm going to be restrained.
Exactly. Or something intensely physical,
Yeah.
which may put their health at risk, which we know that I think it's well understood that being restrained and stress certainly is a significant physiological impact on patients while they're going through
Yeah.
that.
And so those are concerns that should have been raised at the time on the 27th of May in relation to a planned use of force.
Yes.
And indeed as contraindications to that use of force.
Yes. Yes.
The decision, of course, on a use of force is a custodial one, as we've discussed. But in making that decision, it's important for those who are making the decision to have all of that clinical information and the view that it's a concern or a contraindication to the use of force, isn't it?
Well, in effect, it becomes their risk to manage, but they are looking to the medical professionals to give them some guidance as to what the problems might be, not necessarily how to manage it,
Yes.
but that there is a problem and that you need to think carefully about this. Once you've done that and provided that information that you need to be careful in this particular case, then it becomes the custodial side's risk to know how to manage it. And that's why I say it becomes a complex matter,
Yes.
because you would potentially need observation, supervision with a healthcare professional while undertaking that, who has an understanding of what they're looking for in terms of that control and restraint.
Yes. If we look at what happened, there is a transcript of the DCOs who were going to be carrying out the planned use of force, talking about it in relation to D1914 beforehand. We can put it on the screen if it's helpful. TRN 5087, please, at page 20. If we look then a couple of lines down, Callum Tully says, just worried about this guy. Dave Webb, it doesn't matter. Callum Tully, what if he dies? Dave Webb, no, we've got that disclaimer. So what we'll do is in the morning, I'll grab that off Nobby, who's we know is Steve Lawton. I'll take a couple of copies before all the paperwork gets tucked away and I'll give you one. And Callum replies, cool. Dave Webb, so then in that way, if everything happens later on, you've actually got a fucking copy of the doctor's letter. This appears to be DCOs expressly relying upon Dr. Uzerali's approval of a use of force, doesn't it? Would you agree?
Yeah, I think the issue here is, as I sort of as I said earlier, it's the relaying of the risk, isn't it, to the party that are going to be undertaking the use of force, and here, in a way, what they're saying is that Dr. Uzerali is taking on that risk on his shoulders.
Yes.
By saying he's approving for that use of force, but clearly, even essentially the lay people, non-medical people, are aware that this is a concern,
Yes.
and that's wrong in a number of ways. They shouldn't be defending their own actions or the consequences of those actions by simply having a disclaimer, because
Yes.
they have a duty of care also, but they certainly are in a way also misusing the information that's been provided to them in a way which is unacceptable.
Yes. Again, of significant concern.
Significant concern, yes. And it doesn't really take, neither of them take any view of the detained person's perspective in this, which I think is also quite sad.
Yes. A DCO later says in relation to D1914 and the planned use of force, if he dies, he dies, a now rather famous quote from Rocky IV. Dave Webb also demonstrates incorrectly the use of a shield to Callum Tully, who's going to be the one using the shield. This disclaimer, as they put it, seems to have put Dr. Uzerali's patient in harm's way, doesn't it?
Yeah, absolutely.
John Collier, who's the inquiry's use of force expert, considered the use of force on the 27th of May 2017, and he concluded at paragraph 124 of his report, my opinion and the reason for this incident being of high concern is that D1914 did not offer a level of threat to staff that justified their actions. If a full assessment had taken place prior to the intervention, I would not have expected to see them in full PPE. The force used was not necessary, and more time should have been taken to try and persuade compliance with the instruction to move. I am even more concerned at the lack of consideration for the condition of D1914, who appeared unwell and unlikely to present a safety risk towards staff. So that was his view. Does this incident show effectively a link between potentially life-threatening ill treatment in the context of a seriously ill man and a systemic healthcare problem in the sanctioning of use of force by doctors?
Yeah, I think that's probably fair. I mean, the only other thing that seems to be a factor in my mind, having read through the records, is whether there was a preconceived idea about the offending history, whether that played a part here, and people were just naturally nervous about that, and so felt that they had to escalate, and that is something that we frequently see, that the mechanisms are ratcheted up in order to sort of combat a particular situation rather than de-escalation. So
Yeah.
I take Dr. Collier's, Mr. Collier's views, that it seemed to be excessive, but I'm not obviously, as you know, an expert in the area.
So stepping back and looking at the whole course of events in relation to this gentleman, there were a series of failures in the safeguards against detention of vulnerable people and treatment of his behavioural response to his mental illness as refractory behaviour, as we discussed, in the absence of treatment of him, which resulted in him being exposed to ill treatment in the form of an unnecessary and excessive use of force against him.
Yeah. Yes.
Dr. Uzarali, as I've mentioned, completed a Rule 35-1 report for D1914 on the 17th of July 2017 that stated he had no mental health issues. And this was despite the fact that D1914 had recently attempted suicide. So that wasn't accurate, was it?
No.
He should have recorded mental health issues leading to a serious act of self-harm, shouldn't he?
Yes, at the very least.
At the very least. And given that omission, that report is completely inadequate, isn't it?
Yes,
And indeed done too late.
indeed.
If we look then next, please, at D687, you have dealt with him in your report, both reports as well. Let me see if I can find the page reference, sorry. He is at page 26 of your supplemental report, sorry. So D687, we know on the 15th of April 2017, Dr. Uzarali completed a Rule 35-3 report for him, but did not provide an opinion with regard to the impact of ongoing detention at that stage. And you say, in my view, Dr. Uzarali should have provided his opinion in regard to the impact of detention on D687 in this Rule 35-3 report, as directed by the form, indeed. Is that right?
Yes.
Despite this, the Home Office's response concluded that D687 met the threshold for an adult at risk, but that their decision was to maintain detention at that time. So again, the Home Office, having received a report, certainly didn't take a decision to release D687, potentially because the impact of detention hadn't been commented upon by Dr. Uzarali.
Yes, the absence of the information appeared to reassure them that things should just carry on as they were, detention should continue.
On the 5th of May 2017, D687's condition was noted to have deteriorated and he was placed on an ACDT as a result of a reported intention to take an overdose. An appointment was made for him on the 10th of May to see the GP, but he didn't attend. There wasn't any Rule 35-2 report provided at this stage, nor indeed a Rule 35-1 report notifying the Home Office of an apparent worsening impact as a result of ongoing detention on him. And you say, in your view, there should have been.
Yes.
In relation to both Rule 35-1 and Rule 35-2.
Yes.
You also comment about the lack of follow-up in relation to him missing his appointment with the GP.
Yep.
And you say that it is my view that the missed appointment on the 10th of May ought to have been followed up with a further appointment with the GP in order for them to assess the detained person and complete the relevant Rule 35-1 and or Rule 35-2 reports, given that you say it's only a GP who can complete those reports.
Yes.
And you say
in the circumstances that the GP was either unavailable at the time or the detained person remained unwilling to attend for an assessment, then in my view the GP should have completed the necessary reports based on the available records, notifying the Home Office of the change in circumstances. Is that right?
Yes, yeah,
Because there was enough information already to trigger the threshold.
exactly.
On the 13th of May 2017, there was a planned transfer to the Verne IRC, and D687 protested by placing a ligature around his neck, and that was subsequently removed during a use of force. Are you aware of that?
I am, yes.
There was no entry in the medical records indicating that an ACDT was opened whilst D687 was still in Brook House. Should there have been any?
Yes, even though he was leaving.
It appears that following this particular incident, D687 was successfully transferred to the Verne IRC, and according to the additional medical records you've been provided with, he was subsequently placed on an ACDT there, and you say he should have been placed on one at Brook House.
Absolutely.
And also that the ligature incident should have prompted the provision of a Rule 35-2 report at the time whilst he was still in Brook House.
Yes. Just because he was leaving shouldn't have prevented them from following their duties to notify the Home Office.
Yes, particularly as he was still going to remain in detention.
Absolutely, yeah.
And you say, I note that following transfer to the Verne and the subsequent commencement of the ACDT, there doesn't appear to have been a Rule 35-2 report provided there either.
No.
It appears by the time D687 was involved in the incident on the 13th of May, he had been presenting with deteriorating mental health symptoms for almost 3 months. Is that right from your review of the records?
I believe so, yeah.
He hadn't been prescribed any medication for that, such as antidepressants. During that time, he described multiple incidents in which he expressed suicidal ideation to staff, including the healthcare staff. You note that it was clear by his Rule 35 assessment on the 15th of April that his mental health was deteriorating, but that wasn't communicated to the Home Office by Rule 35-1.
It wasn't.
And you similarly say that by the 10th of May it was clear that his mental health had deteriorated further since his Rule 35 appointment with Dr. Usrali on the 15th of April. Yet again, that wasn't reported by Rule 35-1 or Rule 35-2. Again, those indicate significant failures in the safeguards.
Indeed, yes.
The Home Office, as we've just discussed, approved a request by G4S to transfer him from Brook House to the Verne, which did take place on the 13th of May. As a result of Dr. Usrali's failure to report D687's mental health deterioration to the Home Office, that was something that they couldn't have factored into that decision whether or not to transfer him. Is that right?
It is. The question that arises in my mind here is what could be the reason, and what was the reason for the request for the transfer, and the pessimistic side of me feels that it was done again for convenience, that he was problematic in a way, and therefore transfer might be in their interest, not the detained person's interest.
Yeah, and the Home Office should have been aware of that deterioration in
Correct.
making the transfer decision, shouldn't they?
Exactly. So, again, what it speaks to me of is this kind of out of sight, out of mind approach, which, had they been following the processes for them in terms of advocating for their patient and notifying the Home Office, you're absolutely right. They would have then been able to factor that information into whether the transfer was in the detained person's best interest or not.
So a transfer shouldn't have been attempted before he'd seen Dr. Usrali following that missed appointment.
As I say, I don't know the full reasons for the request for the transfer, but certainly a decision about that, I don't think, could have been made without notification of that deterioration and the additional very recent self-harm that happened at that time.
Yes. In relation to his mental health, it was also untreated, wasn't it? He wasn't receiving antidepressant medication, nor indeed any other treatment. Should he have been prescribed antidepressant medication by Dr. Usrali following his appointment on the 15th of April?
It's a difficult one to answer because on one hand I don't know whether clinically an antidepressant would have been the right treatment, whether it was even what the detained person wanted in terms of treatment, whether it was offered or not, whether it was considered or not, I don't know. But arguably, I guess we're slightly deflecting away here from the real issue, which is that actually an antidepressant wouldn't necessarily have prevented deterioration. It's not a prophylactic treatment for the prevention of deterioration in immigration removal centre. That's not what it's for. So I think wouldn't want that to distract us from the important issue that if there is deterioration, simply prescribing an antidepressant
Isn't the answer.
Isn't the answer.
Dr. Uzrali was asked about his consideration of antidepressant prescription on the 15th of April. I asked, did you consider prescribing antidepressants as a result of this consultation? And he said, the role of it doesn't, I think it should say look, but it does not say there, I didn't consider it. Pausing there. Another way of putting that is, it doesn't say I did consider it. It's an interesting phrasing by Dr. Uzrali.
Yes.
It doesn't look like I decided at that point it was required. Antidepressants don't necessarily define someone's depression. It appears, at least it wasn't documented as being considered. It appears it wasn't considered until the 8th of May, when mental health nurse Karen Churcher raised the possibility and referred him for the further appointment with Dr. Uzrali on the 10th of May to discuss it further. We know he missed that appointment and he wasn't seen by Dr. Uzrali again before his transfer to the Verne, and you also commented on that in your report, and that steps should have been taken to follow him up with another appointment or submit a Rule 35(1) report on the basis of the records.
Yeah.
The reason it was important for his non-attendance to have been followed up, because the reason for the appointment was to do with a deterioration and a consideration of antidepressant medication, wasn't it?
Well, it was to do with the deterioration, primarily in my mind. As I said, I don't think the consideration of medication in and of itself was the reason for the follow-up. And I can't remember the detail. I'd have to look at the clinical entry for the Rule 35 report, but there certainly is enough information in there to, had it been a normal GP appointment, if you like, to have considered somebody who was depressed and whether I should treat it.
Yes.
And that would have been an adjunct if I was treating it in terms of his depression, if that was the case at the time.
Yes, I see.
Rather than the only reason for considering the mechanisms that definitely needed pursuing.
Yes. In your supplemental report at page 81, you say, I do have a concern that there does not appear to have been a consistent mechanism or approach to the follow-up and review of detained persons considered to be a victim of torture or an adult at risk where GP appointments have been missed, ensuring that possible deterioration as a result of ongoing detention is monitored and detected adequately. That appears to be a systemic failing.
It does, and I can hear the people that are in the position of responsibility for resourcing this, with their hair standing on end. How on earth am I going to do this? I can see there'd be a massive impact in terms of how you would organise your healthcare around that mechanism. But it seems, having reviewed all of this material, that is essential.
Yes. D687's description of the incident on the 13th of May with the ligature during his removal attempt is at paragraphs 194 to 214 of his witness statement. And he describes there having given up on life, having lost hope and feeling worthless. And he explained how all of those feelings and others described in his statement contributed towards him attempting suicide on the 13th of May 2017. He says he wanted to die. Do you think that D687 not having been taking antidepressants is likely to have contributed to his experience of the incident on the 13th of May or not?
I think the challenge here is if an antidepressant was considered, it would have been, in my view, I think too early on in the treatment to have made a difference, a realistic difference, because you need to be on an antidepressant for a considerable period of time for it to reach its full effect. Mm-hmm. And that's variable from person to person. Equally, some people may not get on with an antidepressant, so you need to try a different one. I think my understanding in terms of the timeline is it was too recent between the transfer when it could have started to have made any reasonable difference to his experiences on that day.
You note that there's nothing in the System 1 entry for the 15th of April in respect of D687's Rule 35 appointment to indicate whether or not Dr. Usrali considered opening an ACDT at that time.
Yeah.
D687 has told the inquiry in his witness statement at paragraph 158 that the Rule 35 report doesn't properly reflect the interaction he had with Dr. Usrali on the 15th of April. He disclosed certainly self-harm from 2 days earlier and showed the doctor fresh scars, and the doctor, he says, wasn't interested. He said he described the attitude of healthcare staff in his witness statement, and he said it felt like they didn't care and that they didn't believe you if you said you were unwell. They just wanted to move people along, and nurses were just handing out paracetamol, effectively. I'm summarising. In your view, if a vulnerable individual was to be met with attitudes such as those that D687 describes there, what impact would that have on their likelihood to make disclosures to healthcare of traumatic events in their life?
Well, they're less likely to, and we certainly know that some people won't necessarily disclose from the outset because of the perhaps shame or other emotions that they may have in relation to those incidences and the lack of confidence in the system, the authority, if you like.
Yes.
So it takes time for that to happen, and if you are then met with, disbelief, disdain, you're, a nuisance, or that you're trying to subvert the system, that isn't necessarily going to be received well, is it?
No,
I think
and would it
you're
also
unlikely
have...
to trust,
Yes.
or you're less likely to trust.
Yes, and would it also have an effect on the detained person's mental health generally?
Yeah, absolutely. Yes.
A negative effect?
Negative.
Do you consider that Dr. Usrali's failures in relation to Rule 35 contributed to the incident on the 13th of May because they led to an absence of a detention review, meaning he remained in detention, deteriorated, and then was subject to a use of force?
Yes.
Chair, slightly early, that may be an appropriate moment to pause, just because I'm going on to another case study that's quite lengthy and we may then go for a period of time.
Thank you, that makes sense.
Can I say 5 to 2, please?
Indeed, thank you, Dr.
Right.